Hello students, how are you? Let's do the topic inquiry and trial under CRPC. What is the difference between inquiry and trial under CRPC? Trial is not defined in CRPC. Trial word is not defined anywhere. Even in the definition sections also trial is not defined. But inquiry is defined under section 2 clause G of CRPC. It's a very simple definition. Inquiry is conducted by the magistrate or the court, and it can be judicial as well as non-judicial. The accused can be administered oath by the magistrate during inquiry. The scope of inquiry is wider than the trial. How? Because in inquiry the judge can put any questions he likes. The question may not relate to the particular case itself. That the judge can ask any question which may not relate to the or which may not directly relate to the offense. So it's wider in scope as compared to trial. Trial is also conducted by the magistrate. Inquiry is also conducted by the magistrate. But these are the two different stages of the criminal proceedings. The trial's scope is narrow than the inquiry. If the trial starts, it results in two ways. Either the accused will be convicted or he may be acquitted. But if the inquiry starts, either the accused will be discharged or the magistrate may frame charges against the accused, and once the charges are framed or once the court takes cognizance of the matter, the trial starts. When the inquiry ends, the trial starts, or we can say the trial starts once the inquiry ends. So these are the two stages of the criminal proceedings. The first stage is the investigation, the second is inquiry, and the third is trial. Investigation is done by the police, inquiry is done by the magistrate, and trial is also done by the magistrate. After inquiry stops, trial starts. So all the proceedings before the magistrate, before taking cognizance of the case, before the magistrate takes cognizance of the case, up till that stage, all the proceedings is inquiry itself. It's inquiry. But when the magistrate takes cognizance of the case, then the inquiry ends. Or once the magistrate frames charges against the accused, he frames written charges against the accused, the inquiry ends and the trial starts. Now some people say that trial actually starts when the magistrate file a written charge against the accused. When the magistrate files the written charge against the accused, then only the trial starts. But actually this is not true. You see, written charges are framed by the magistrate or the court only in session cases or warrant cases. These are the serious cases. In these cases, written charges are to be framed by the presiding officer. But as far as non-serious cases, less serious cases are concerned, the trial is different. And those trials are known as summary trial or summons trial. So in summons trial or summary way, the procedure is very, very lenient, and a simple procedure, no written charges are framed by the judge. So when the trial starts in those cases, so a generalized viewpoint is this, that actually the trial starts when the judge or the magistrate takes cognizance of the matter. Now you will say, what is cognizance? Cognizance means when the magistrate or the judge applies his judicial mind on the case which is before him. What is judicial mind? When he thinks that yes, this case needs to be proceeded further, the allegations or accusations against the accused, that is, if the case is started by the police, then the allegations contained in the challan or the police report, or if the case is started with the complaint, private complaint, then the allegations or accusations given in the complaint are heavy enough, they carry weight, and the accused need to be tried before the court. The accused need to be tried before the court, or at least he should be brought before the court, summons or warrants should be sent to the accused and he should be brought before the court and the court should examine him. The magistrate should examine the accused. At that point of time, the magistrate put any questions to the accused. You see, at that time, when the accused is brought before the magistrate, at that time the magistrate has not framed the written charges. At that time, the magistrate only put certain questions to the accused, and that may be non-judicial also. He can put any questions to the accused so that he may know about the truth and falsity of the allegations against the accused and what he wants to say. The judge may ask certain questions to the accused or even to the prosecutor and take their answers. And after analyzing all these things, after conceptualizing all these things, if the magistrate or judge thinks that the allegations or the accusations against the accused does not carry weight, they are not so heavy, then the accused may be discharged by the judge immediately. If the judge thinks that the allegations are not so serious, the judge may or the magistrate may discharge the accused immediately, and then the case will be dismissed at that point of time. But that is not a guarantee that next time a second complaint may not be filed against the accused. That is the right of the complainant. Even the police can file a second challan or after further investigation. That's a different area. But at that point of time, the accused is discharged. But if the judge thinks that yes, the allegations or accusations against the accused carry weight, they are heavy, and the accused needs to be tried before the court of law, and then the court or judge will file written. He will frame written charges against the accused, and once the written charges are framed by the judge, then the trial actually starts. Actually, trial starts before actually written charges, when the court takes cognizance of the case. Many advocates say that when the court files written charges, then only the actual trial starts. But actual trial starts when the court takes cognizance of the case. Now, when the court takes cognizance when the court thinks that yes, the accused need to be brought before the court by sending summons or warrants to him, and he should be put questions so that the court may decide whether actual trial should start or not, whether actually charges should be framed or not. Now, whether actually charges should be framed or not, here the judge is applying his judicial mind. It is here where the judge applies his judicial mind, and once the judge applies his judicial mind, then and there actual cognizance is taken by the judge and the trial starts. Charges framing is the formality then, and if the charges are framed, then the trial will end in two ways. Either the accused will be convicted or the accused will be acquitted. But when the charges are not framed, by the judge, then the accused can be discharged. But if the written charges are framed, then the accused will not be discharged by the court. Then he can either be convicted or he can either be acquitted. So this is the thing. So inquiry results in two things: either discharge of the accused or the judge may frame charges against him. So through inquiry, the magistrate actually determines whether charges should be framed against the accused or whether cognizance should be taken or not, whether evidence against the accused is strong enough to commit him to trial. So all these questions are in the mind of the judge before framing the charges, because framing of the charges is a serious thing. A person's right to life is involved here. Everybody has a right to life, everybody has a right to freedom. So nobody can take the freedom of anybody, even the court cannot. So court thinks many times before framing charges. But once the charges is framed, then the accused can either be convicted or acquitted. He cannot be discharged. So inquiry under CRPC, there are two types of inquiries. Under section 159 CRPC, when the police files a challan or a police report. Under 159 CRPC, when the police files a FIR, the police registers an FIR under section 154 of the CRPC, then one copy of the FIR sent directly to the Ilaka magistrate. Now Ilaka magistrate will read the FIR. Under section 159 CRPC, after viewing or reading the FIR, if the magistrate thinks that the evidence against the accused is enough and the investigation should be carried further, then the court may direct the police officer to further carry on the investigation. Or actually 159 CRPC power of the magistrate is like this. If after registering an FIR of a cognizable offence, the police has the discretion in cognizable case, even after registering the FIR, the police may not go for search of the case, the police may not investigate the case. These are the certain discretions of the SHO or the police officer of the concerned police officer. He may not go and search, he may not investigate the case if he thinks under his discretion, there is a lot of discretion to the police officers that the case does not carry any weight and there is no need to further investigate the case. He may file a cancellation report also. At that point of time, under section 159 CRPC, the magistrate may ask the police officer that no, you carry on the investigation. Why you are stopping the investigation? But once the investigation has been started by the police under section 154, after filing the FIR, written FIR, the original investigation cannot be stopped by the judge. It will be continuing. So this is the inquiry. The judge inquires under 159 that what the police is doing after registering an FIR, whether police is actually going to investigate the case or not. So judge keeps all this in mind and judge take control of the matter. But judge does not interfere in the investigation. Investigation is the job of the police. Judge only sees that what the police is doing, whether the rights of the accused are not being violated by the police. So this is the main thing. So under section 202, this is the second time when the inquiry is done by the judge. Here under section 159, in the case of police report, in case of challan. Under section 202 CRPC, in case of private complaint also. If the private complaint is filed by any private person against any private person under section 200 of CRPC, then under section 202 of CRPC, and in case of private complaint, the judge may not frame the charges at that point of time, because charges are framed under section 211 of CRPC, which will come afterwards. At this time, when the complaint is before the judge or magistrate, the judge may read the complaint, and after reading the complaint, after analyzing all the evidence and witnesses, he's prima facie of the view that it does not carry any weight. The substance or the allegations or the accusations given in the complaint does not carry any weight against the accused. He may immediately discharge the accused and he may dismiss the complaint. Okay, so this was the inquiry. Now as far as trial is concerned, as you know, I have already told you, trial comes after the stage of the inquiry. The scope is very narrow, because in trial either the accused can be convicted or acquitted. Trial starts when the court or the magistrate takes cognizance of the case before him. That is when he applies his judicial mind to the case and decides to proceed with the case further. I have already told you what is meant by applying the judicial mind. Okay, so magistrate thinks, if the magistrate thinks that the case is fit one to be tried in the court because the accusations or the allegations against the accused seems to carry weight, due to which it is very important that the accused should be brought before the court by issuing summons or warrants. Summons and warrants are issued under section 204 of CRPC. So after issuing summons and warrants, once the accused appears before the court or the magistrate, then the court or the magistrate may put certain questions to him. Whether those questions may be relating to the case or they may not be relating to the case. And even certain questions are put to the prosecutor also. So both parties are before the judge or the magistrate, and judge at that point of time is putting certain questions to both the parties, accused and the prosecutor. And after getting their answers and after examining the accused, if the judge thinks or the magistrate thinks that the allegation against the accused seem to be groundless, the allegations are groundless, and the magistrate thinks that the case need not to be proceeded further, the charges need not to be framed, so judge may at that point of time discharge him immediately. But if the magistrate frame written charges, then the accused cannot be discharged. Charges are framed under section 211 of CRPC, then the accused can either be acquitted or convicted. So this I have tried to explain to the concept of inquiry and trial. I hope you have understood, and I try to make this concept very easy for you. So I hope you like the lecture, and please subscribe this channel, and so that I can put more and more videos, informative videos for you. So subscribe it and watch the videos continuously. Thank you very much. Sat Sri Akal.